Hello, everyone. My name is Susan Lawrence, and I'm a partner at Thompson Coburn's Labor and Employment Group. I am here with my colleagues, Emma Lapp and Anthony Whalen, and we are here today to discuss with you recent updates and developments in the law related to the Americans with Disabilities Act, or the ADA, as you're going to hear me repeatedly say today. Before we begin, we wanted to cover just a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try to answer those during the webcast, but if a more complete answer is needed, or if we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. Today's presentation is CLE accredited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional attorneys. 1 hour of HRCI credit and 1 hour of CHRM credit is also approved. We award CLE based on attendance for the entire 60 minutes. We will display secret words in 2 multiple choice polls during the presentation, and you will be required to select today's secret words from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in the course, and will be given an option of providing detailed response at the end. All right, so with that, by way of introduction, I wanted to give you a quick roadmap on what we plan on discussing today. I will start by providing some analysis on 2 appellate decisions that came down already this year that focus on 2 particular aspects of the ADA that employers frequently grapple with, namely the duty to provide reasonable accommodation and the usage of medical examination. I will also provide an update on a recent district court opinion that relates to accommodation requests and dress codes. I'll be going over the effects of these cases and what each have on the interpretation of the ADA, and how they might change how employers interact with employees with respect to disabilities and accommodations. Next, Anthony will provide some insight on the specific accommodation of requesting to work from home under the ADA, and how appellate courts have been dealing with the ADA accommodation request to work from home in light of the COVID-19 pandemic and the workplace changes that we have all come to know following the pandemic. Anthony will give some tips on best practices for employers when preparing for a work from home accommodation request, and what to keep an eye out for when an ADA work from home request comes your way. To finish things off, Emma will be providing us with a deep dive of the multiple ways states are dealing with the use of medical marijuana in the workplace as an accommodation. She will be giving us a review of medical marijuana laws across the country, analyzing how the legality of marijuana at the state level interacts with an employer's desire or obligation to keep the workplace safe and drug-free, all while making sure not to run afoul any anti-discrimination laws. As I said before, at the end of the presentation, we will answer any questions, provided there is time remaining. Before we get into these important updates, I thought it would be helpful to level set to ensure that we're all on the same page as to what the ADA is and what it requires of employers and employees, which we will frequently call back to during this webinar. As we know, the Americans with Disabilities Act prohibits employers from discriminating against qualified individuals based on their disabilities. This discrimination can take place in the application process or after an employee is hired. Generally speaking, the ADA requires an employer to provide reasonable accommodations to a qualified individual with a disability, provided it does not place an undue hardship on the employer. The ADA defines qualified individual as someone who can perform an essential job function of their position with or without a reasonable accommodation. In a second, we'll be focusing on that with or without language in greater detail. As most of you on this call know, the key with any ADA request is to examine three key parts. First, the disability or condition an employee has. Second, the essential job function that is being impeded. And third, the reasonable accommodation that brings about a solution and allows the individual to do their job to a reasonable expectation of the employer. Let's take these one by one, again, just to make sure we're all on the same page as we're navigating the topics we're going to be discussing today. The ADA defines a disability as an impairment that substantially limits one or more major life activities. In 2008, Congress amended the ADA to broaden the definition of disability, including by expanding the list of major life activities so as to ensure more employees were protected by the Act. For example, the most basic actions like breathing, standing, sitting, or bending were added as lists of major life activities, as were mental tasks like communicating with others, reading, or concentrating. As a result, it's often futile to challenge an employee's claimed disability as a basis for rejecting a request for an accommodation. Suffice it to say, we need to be thinking very broadly about the concept of a major life activity, and very few claims, if any, would not implicate a major life activity. So once we've met that threshold and feel confident that the employee in question has a disability, we next looked to the concept of an essential job function. Under the ADA, essential job function encompasses any job duties, activities, or actions performed in an employment role that are essential. They can vary greatly depending on the position at issue, and so courts tend to look at the facts to determine what an essential job function is. It's not enough just to look at the title or, generally speaking, what industry standard is with respect to that role. These are very factually intense analyses, which is a reoccurring theme in today's seminar. However, the statutory language and accompanying regulations of the ADA do give us a starting point for where to look and what questions to ask when determining what an essential job function is. Federal regulations tell us that a job function can be essential for multiple reasons, such as the fact that the job position exists to perform a particular function or requires a specialized skill or knowledge. The regulations also consider how much time a person spends performing a particular job function or the consequences for not performing the function, among other things. Think in terms of materiality when analyzing whether a job function is essential. The fact that someone may have to do something once or twice a day or a week might not make it essential, but rather something that is repeatedly performed or is key to the task at hand tips it into the essential aspect. The good news for us is that courts are supposed to consider the employer's judgment of an essential job function, and will look to such things as a job description or a job posting as evidence. For that reason, as anyone who has ever worked with me knows, I am a huge proponent of auditing your job descriptions frequently to make sure that they accurately reflect the job and all of its essential functions. I'm also a fan of asking for employee input on what they see as the essential parts of their job. Not only will it assist the employer in creating precise job descriptions, but the employee's own words will come in handy if they ever ask for an accommodation that would eliminate one of those key functions. Finally, there is the reasonable accommodation aspect of the ADA analysis. The ADA's regulations define a reasonable accommodation as a modification or adjustment to the work environment or the manner or circumstances which a position is customarily performed that enables an individual with a disability who is qualified to perform the essential functions of the position. Again, suffice it to say, this is a very individualized assessment rooted in a factually intense analysis. there is no one size fits all when it comes to accommodations. And again, the ADA regulations give us some pointers on what might be deemed reasonable, such as a modified work schedule, reassignment to a different vacant position, and acquiring devices or equipment that assist the employee. As many of you know, this whole process of complying with the ADA and finding out what accommodation works is described as the interactive process and is required by the employer when a request is made by the employee. The employer and the employee must engage in a dialogue to determine two things: the precise limitations resulting from the disability and the reasonable accommodation that could overcome those limitations. The dialogue does not need to be formal, and the employee does not need to fill out a specific form or use any magic words to kickstart the accommodation process. All they need to do is make a request for an accommodation based on their disability. In other words, we can't wait for them to file something in writing with HR to begin this process. We won't spend a lot of time with the interactive process itself, but it is important to remember that employers are within their rights to require certification from the employee's healthcare provider to verify the need for the accommodation. It's also important to note that the employer does not have to eliminate an essential function of the position. This is because a person with a disability who is unable to perform the essential functions with or without accommodation is not a qualified individual within the meaning of the ADA. Nor is the employer required to lower production or performance standards that are applied uniformly to employees with and without disabilities, meaning you don't have to allow an employee to perform poorly at their job as an accommodation. Finally, it's important to note that it's okay if the reasonable accommodation that ends up being offered to the employee is not their first choice. The employee's preference does not automatically control, and the only thing that an employer must do if a reasonable accommodation is needed is provide just that, a reasonable accommodation that allows an employee to perform the essential functions of the job. Now, candidly, I appreciate that that's often the sticky spot in these kind of discussions where we can't give them what they've asked for, but we can give them something else. So I'm not trying to make light of that aspect of it, but I want to make it clear that that is recognized within the ADA and its regulations. The last ground rule we'll discuss before getting into the specifics of the cases we're here to discuss today is the defense for undue hardship. This comes into play if at the end of the interactive process, the framework has been completed and the employee has been able to make the connections to their condition, the essential job function at issue, and they've requested an accommodation that bridges the gap between the two. The employer can then assert an undue hardship in providing that accommodation if the requested accommodation requires significant difficulty or expense, and that is the term utilized within the ADA. An undue hardship analysis focuses on the resources and circumstances of the particular employer in relationship to the cost and difficulty of providing a specific accommodation. But I want to make clear, undue hardship, while referring to financial difficulty, does not rely solely on financial difficulty. It will not pass muster to say something's expensive and therefore we don't need to give it. If the resources of the company allows for the incurrence of that kind of cost, a court will view that as potentially reasonable and not an undue hardship. Again, an employer must assess these on a case-by-case basis when asserting or determining an undue hardship. We must be able to show that by providing the accommodation, we will be unnecessarily disruptive to the business or would fundamentally alter the nature or operation of the business. Okay, now that we have covered those general confines of the ADA and reasonable accommodations, it's time to move on to our first case, Tudor v. Whitehall School District, which explores the concept of qualified individual, the first prong in an ADA analysis. In this case, Ms. Tudor worked as a teacher at Whitehall Central School in upstate New York for 20 years. She suffered from severe post-traumatic stress disorder and as a result had difficulties communicating with others and performing her daily tasks as a teacher. In other words, she had difficulty with major life activities and therefore qualified as a disabled individual under the ADA. In 2008, Whitehall provided Tudor with an accommodation for her PTSD disability by allowing her to leave the school grounds during the teacher prep periods twice a day. These prep periods were 15 minutes in duration and occurred once in the morning and once in the afternoon. Under the accommodation, Tudor was able to spend time away from the workplace as a way to help manage her condition. However, in 2016, a new school administration began to prohibit teachers from leaving school grounds during the prep period, and Tudor received a reprimand for her attempt to take her prep period away from school. The new administration ultimately offered Tudor her requested break in the morning and an afternoon break, but only as long as the librarian could watch her students. In 2019, no other school employee was available to watch the students during the prep period, which meant Tudor could not take her approved afternoon break. This led her to file suit and allege Whitehall's refusal to guarantee a 15-minute break violated the ADA. What makes this case so interesting is that during her deposition, Tudor admitted that she was able to perform the essential functions of her position without an accommodation, but could only do so under great duress because of her PTSD. As a result of her testimony, the district court granted summary judgment in favor of the school, finding that Tudor could not establish her failure to accommodate case if she was able to perform an essential function without a reasonable accommodation. Tudor appealed the case, and the Second Circuit vacated the judgment and remanded the case back to the district court where it still sits today. So let's break this down a little bit. The Second Circuit Court of Appeals took aim at the question of whether Tudor's ability to perform her essential functions without a reasonable accommodation proved fatal to her claim. And I'm just going to pause there to make clear what I'm saying. She could do her job. She did not need an accommodation to do it. It was difficult, and an accommodation helped her do it better and without stress to herself, but she was able to do it. The court zeroed in on the definition of qualified individual in reaching its conclusion that summary judgment was not appropriate. The definition of qualified individual includes an individual who, with or without accommodation, can perform the essential functions of the position that the individual holds, which the district court down below read to preclude coverage for any employee who could still perform without the accommodations. The Second Circuit conducted what it called a straightforward reading of the language and determined that just because an employee can perform her job without a reasonable accommodation does not mean that she must. Said another way, according to this case, an employee with a disability is qualified to receive an accommodation under the ADA even if she can perform the essential job functions without one, and even if it is not strictly necessary to the performance of the essential functions of the job. While this might make sense given the plain language of the statute, it is worth pointing this out because many employers, understandably so, equate the duty to provide a reasonable accommodation with the understanding that an employee can only do the essential functions of the job if they have one. This case makes clear that that is just not so. One other point to point out that the Second Circuit made, which we'll explore further in a bit, is to remind employers that the reasonableness of an accommodation is a fact-specific question. In other words, each case is different and must involve an individualized assessment of the requested accommodation and the employee's job. As this court stated, generally speaking, per se rules are unreliable in the disability context. Before we move on to the next case, I think it makes sense to take a quick step back and do a quick dive into how medical examinations work under the ADA. As mentioned before, the ADA's prohibition on discrimination extends to medical examinations, which are treated differently at various stages in the employment relationship. Prior to an offer of employment, an employer may not conduct a medical examination or inquire as to an employee's disability. An employer is only allowed to make inquiries as to an applicant's ability to perform job-related functions. After an offer of employment, a required medical examination is only allowed if the following criteria are met. All employees are subject to the exam, regardless of whether they have a disability. The information is treated confidentially, and if the examination is used to screen employees, the decision must be job-related and consistent with the business necessity, and no reasonable accommodations can be made to ensure that the essential job functions can be performed. After an employee has begun their position, subsequent medical exams must be performed only when job-related and consistent with the business necessity, such as when an employee returns from leave or an employer is determining that there are specific performance or safety issues. Okay, with that by way of background, I want to look at a recent Seventh Circuit case, Nawara v. Cook County Municipality. This case focuses on John Nawara, a correctional officer at Cook County Jail, which is so beautifully pictured here. In 2016, Nawara engaged in multiple heated altercations with other Cook County employees and was put on leave subject to a fitness for duty test. At no point in this did Nawara mention a disability or use any disability as an explanation for the heated altercations, however. As a result, Nawara avoided signing medical authorization forms related to the tests and had to be put on an unpaid leave while they were working out the authorization issues. Nawara filed suit during this leave, alleging that the ADA's requirements on medical examinations had been violated. While a jury agreed that an examination requirement violated the ADA, they did not award any damages. And the district court found that in order to receive back pay, the employee must either have a disability or be perceived as having a disability. For these reasons, Nawara appealed. The Seventh Circuit ultimately reversed the district court's decision that Nawara was not able to receive back pay. The court noted that the medical examination section can be invoked by any employee, not just those who are disabled or perceived as disabled. The court then determined that a violation of the medical examination subsection of the ADA counted as discrimination on account of disability, even though Nawara did not have a disability, and therefore allowed for an award of back pay. The court based this finding on the fact that the medical examination subsection is unique to the additional examples of unlawful discrimination under the statute, and that simply interpreting a medical examination as a way to discriminate would make the rule superfluous. This case arguably raises the stakes for any employer conducting a medical examination of an employee, regardless of if that employee has or is perceived as having a disability. This worker-friendly precedent means that employers need to be extra careful that they are conducting medical examinations only when they can justify job-related reasons that are consistent with the business necessity. Finally, and in the interest of time, quickly, I want to touch upon Lopez Dupre v. MGM National Harbor. This case is still in the district court and highlights the importance of avoiding relying upon a hard and fast rule when examining a requested accommodation. Here, the plaintiff was a cocktail server at the MGM Hotel and was required to wear black high heels as her uniform. In 2017, she made a request to wear flat shoes, but was denied without any interactive discussion. 2 years later, she made yet another request, and this time MGM provided an accommodation request form to Lopez Dupre's doctor, who responded with a specific type of shoe he suggested she wear. In 2019, at that time, MGM granted the request, and she was able to receive her requested accommodation to wear the support shoes recommended by her doctor, which she did without any event for 2 years. Then in late 2021, MGM established an updated shoe standards for employees who handled drinks, like Ms. Lopez Dupre, and provided a list of 3 non-heeled shoes for employees to wear if they have ADA accommodations. The 3 non-heeled shoes on the list did not include the shoes the employee's doctor recommended, i.e. the shoes she'd been approved to wear. Lopez Dupre continued wearing her previously approved shoes, but soon thereafter received job reprimands for them, and she was eventually terminated for failure to follow the appropriate appearance standards. She sued under the ADA and Maryland state law, but the court denied her request for summary judgment. The main reason for denying her motion was that the court saw as a factual dispute whether MGM's refusal to provide Lopez Dupre's requested reasonable accommodation of particular shoes was in fact a violation of the ADA for their failure to grant her reasonable request. MGM argued that it did not have to allow the employee to wear the specific shoes she requested, but rather that it met its obligation when it offered her 3 different options. Because the motion for summary judgment was denied, the case will now proceed to trial, and we'll find out if MGM's argument ultimately carries the day. But what this case clearly shows is that there is a danger in relying on a hard and fast written policy, even those with some limited options, when assessing an accommodation request. Rather, employers must instead engage in an individualized assessment when making their determination and really decide how confident they are in their ability to argue that one different shoe is an undue hardship on the employer when they already have approved 3 other different shoes. Now that our review of these ADA cases is complete, I'm going to hand over the floor to Anthony to discuss work from home accommodations. But first, we have our first secret word. Today's first secret word is toxic. Please select the correct word below. Again, the first secret word is toxic. All right, and now we are going to move over to Anthony.
Thanks, Susan. Hi, everybody. My name is Anthony Whalen, and I'm an associate at Thompson Coburn's Labor and Employment Practice Group. As Susan mentioned, this section focuses on a subset of accommodation requests that are becoming more and more popular. That is, the request to work from home. Susan gave a great overview of the ADA and the accommodation process, and her insights carry over heavily to this part. Just like any other ordinary accommodation request, the request to work remotely, either full-time or part-time, needs to be looked at using that framework Susan pointed to earlier, and it's 3 main factors: the disability or condition that an employee has, the essential job function that's being impeded, and the reasonable accommodation that pulls everything together. Before I dive into talking about case law and research about the work from home accommodations, I wanted to zoom out a little bit outside the legal context. When we hear the word reasonable, we might be thinking about it in a way that we use it normally. According to Merriam-Webster's dictionary, reasonable is something that's not extreme or excessive, or it's something that's moderate and fair. Now, I know we all went through COVID-19, so it may be easy for an employee to just assume that working from home is reasonable, and so they should be allowed to do so. After all, we were all working remote during COVID, so it surely can't be that extreme or excessive anymore. Not exactly. Like Susan mentioned, for us, reasonable accommodation means something more under the ADA. It's designed to enable a disabled employee to perform the essential functions of their position. That's much different than being just sensible or fair. And accommodation is only reasonable, not if it's fair, but instead if it's sufficiently targeted and crafted to the employee's own needs. So, how much has changed for work from home as a reasonable accommodation since COVID-19? The answer is a little more complicated. There have been some changes, but not as much as you may expect. This is why we spent a good amount of time discussing the framework of the ADA. You may know or may have caught on during this presentation, but the ADA is very fact-specific and does not have many bright-line rules. Instead, under the ADA, a court will take in all the facts. And because that fact-intensive analysis is what the courts are doing, it only makes sense for employers to do that analysis as well. It's also worth noting that remote work has been on the radar with respect to the ADA for some time now, surprisingly enough. The EEOC's 2002 guidance on reasonable accommodation and undue hardship discussed working from home. The EEOC applied the same framework that we do today and said that work from home must be provided only if it allows for the performance of essential job functions. It said that while some positions simply need to be in person, like face-to-face service roles, it described some other job functions as critical, including the ability to supervise employees or work with certain equipment and tools on site. Courts were even less receptive to work from home accommodations in the past. It was not unheard of for a court to uphold a remote work request pre-COVID, but many appellate courts from the late 90s, 2000s, and even the mid-2010s were quick to point out how important workplace attendance was. Courts said things like, most jobs require the kind of teamwork, personal interaction, and supervision that simply cannot be had in a home office situation. They also argued that it would take a very extraordinary case for an employee to be able to create a triable issue of the employer's failure to allow an employee to work at home. But don't get me wrong, the legal landscape is showing slow but steady signs of shifting. In 2023, Bloomberg Law reported that in a post-COVID bump, federal courts have slowly began to rule in favor of employees more often in disputes regarding an accommodation request to work from home. From 2017 to 2019, Bloomberg Law found that federal courts ruled in favor of employers about 70% of the time, and they were able to point to 30 rulings to analyze. But in 2021 to 2023, not only did employers' success go down to 60%, but the legal disputes surrounding a work from home request doubled, with their analysis expanding to 64 rulings. Legal opinions aren't the only place where the shift towards work from home requests is visible. This year, FMLA and ADA administrator AbsentSoft surveyed employees and HR leaders to understand the current state of accommodation requests. AbsentSoft found that HR leaders saw requests for accommodations on the rise both in 2024 and in 2025, and that remote work was the most common request made by an employee, at just over 50% of all accommodation requests made. To get a better idea on what courts have actually been saying about work from home accommodation requests, we reviewed decisions from every federal appellate court since the start of 2020 relating to work from home requests under the ADA. Since appellate courts give deference to the facts and the focus on the law, in our case that being the ADA itself, any big changes to how the ADA addresses work from home would be best found in these decisions. But, as mentioned before, appellate courts are still largely focused on drilling down to the facts and have yet to make any grand statements about any work from home revolution. According to the circuit courts, they've stuck to their ADA analysis guns. And again, they focus on the framework: disability or condition, essential job function, reasonable accommodation that relieves the conflict. Some courts, however, did provide some reflection that's worth homing in on. The Seventh Circuit, which includes Illinois, Indiana, and Wisconsin, was candid about COVID-19's impact on the workplace in the case Kinney versus St. Mary's Health. Ms. Kinney was a director of imaging service at St. Vincent's Hospital, but had to remote work due to COVID-19. When safety protocols were put in place and employees were asked to come back to the office, she didn't return because she believed that wearing face coverings increased her anxiety and prevented her from working. Her request to work from home full-time was denied, and so she eventually resigned and filed suit. The district court ruled in favor of the hospital, and the Seventh Circuit affirmed, but because Ms. Kinney's job description required her to wear personal protective equipment. In doing so, the Seventh Circuit recognized, though, that just assuming in-person attendance is a basic requirement cannot be used in today's world because of the technological advancements and the lessons learned from COVID-19 when it comes to performing away from the office. While temporary work from home during COVID didn't disprove any argument of essential job functions, the court said whether a specific job has essential functions that require in-person work has become much more of a case-specific inquiry. Other decisions have echoed this as well. The Fifth Circuit, covering Louisiana, Mississippi, and Texas, dealt with work from home requests in Montague versus U.S. Postal Service. when an employee had trouble coming to work in the mornings due to her neuropathy. Ms. Montague requested to work from home at the start of her day, but was denied. The Fifth Circuit reversed the district court's grant of summary judgment. The court looked at Ms. Montague's position and disputed whether she really needed to travel into the office during the mornings as an essential job function. It also thought the alternatives suggested, such as taking a taxi to work each day or having Ms. Montague have her husband drive her to the office, could be found as unreasonable. The court noted at the end that regular worksite attendance is an essential function of most jobs, but that this was a partial work request, and that could be appropriate based on the facts. The DC Circuit has also disclaimed any per se understanding of work from home requests in Ali versus Reagan, a unique case where it was the employer who attempted to force an employee to work from home because of his severe allergies. The DC Circuit took issue with the employer's handling of the interactive process and whether work from home would actually solve the allergy problems, which ranged from a particularly pungent cologne of a coworker to residue from printers. They did ask the employee to stop wearing the cologne, by the way, but he said no. Despite the odd nature of this case, this court stated that whether proposed by the employer or requested by the employee, the reasonableness of telework cannot be presumed. That takes us to the third part of my discussion, where we try to put what we've learned into practice, preparing and responding to work from home requests. Before a work from home request is even made, there's lots to be done. The job description serves as a starting point for what job functions are essential, and it's a great way for the employer and later the court to have something to discuss about the work from home accommodation being feasible or not. In contrast, employers should be wary of undetailed or non-existent job descriptions that do not back up their beliefs or the employee's essential job functions. The USPS case in Montague was undermined by the fact that the alleged essential job function of traveling was nowhere to be found in the actual job description, hurting their case. Think hard about what it is that an employee is doing day to day and ask if any of these tasks can or can't be done from home. Sometimes this is simple, as employees may just not be able to complete their jobs or interact with others away from the workplace. But even in positions that may seem okay for work from home, might have some in-person components that require some deeper thought. In 2020, the First Circuit in Trahan versus Wayfair, Maine, found that a call center employee could not perform all the essential functions of her job from home because she was subject to direct supervision and was frequently working in a team-oriented workforce. The Second Circuit in Francie versus New York said something similar about complex collaborative projects. And the Seventh Circuit as well in Belinsky versus American Airlines found that impromptu and face-to-face meetings require an employee to be in person. Employers, like Susan said, should try to update job descriptions at least on an annual basis. But it's important for those changes to be accounted for. In Belinsky, the employee was initially able to work remotely in Chicago because her job let her work independently. But after an employer's merger, her job duties evolved to being much more team-focused, so the prior accommodation became infeasible. Supervisory side, employees should consider if they administer safety procedures or provide coaching and instruction. They're likely to have in-person attendance as an essential job function, but don't take that as gospel. The Eighth Circuit case of Mobley versus St. Luke's Health System had the court question whether a customer service manager could perform his essential job functions at home in response to his multiple sclerosis, pointing to a current policy that let him work at home 1 day a week and his positive performance reviews. Also consider whether the employee needs to access documents on site, and if any of the information handled is confidential or sensitive. This information might not be able to be digitized, and security concerns can be a difference maker. It's important to think about medical and financial information or any government documents that might otherwise be considered sensitive and should not be taken out of a secured workplace. Job descriptions are not the only place to look. Workplace policies are a lightning rod for attention as well, especially work from home policies. Be wary about work from home policies tied to performance or those that are discretionary. Even though these policies may be evenly enforced, this causes thorny issues when it comes to an employee who needs to be accommodated. Be extra careful that the poor performance by an employee isn't actually a symptom of their disability, and that the work from home that they haven't been quote unquote qualified for based on performance is not actually the reasonable accommodation that would help them perform better. Preparing in advance is essential, but can only go so far. We won't know about an employee's disability or the specifics until they actually ask to work from home. There are some important steps to take once the request is on your desk. First, there's the interactive process. The employer can request additional info, including medical documents, if it's not already known or obvious that an accommodation is needed. Many conditions that employees have, like mental health, may not be visible. So an employer can usually request documents necessary to substantiate the disability and identify the various requests that provides a solution. Once you have a doctor's note, analyze it critically. The fact that a note exists on its own is not some shortcut to an accommodation being reasonable, and being thorough pays dividends. Make note that the note actually identifies the disability at issue, and it's the same disability the employee alleges. This sounds simple, but can be easy to overlook. A generalization by an employee or a doctor about health does not trigger the accommodation process. That information must be sufficiently direct and specific. Another simple but key question is whether medical documents actually require or even suggest the work from home. Look carefully at how the medical provider described the employee's solution. Does it say that they can only work from home, or is it just an option, or it may be needed? This seems pedantic, but can make all the difference. The Fourth Circuit has held on multiple occasions that unless the documentation says that remote work is required, an alternative accommodation would be appropriate. Also remember to ask if work from home is feasible. Sometimes it's an easy yes, but don't assume. As Susan mentioned, undue hardship looks at undue expense and undue burden, such as administrative issues that come into play when an employee asks for work from home. An employer under the ADA has no obligation to alter a job in a way that removes an essential job function or shifts an essential function to another employee. An employee might come with a few talking points in the moment to support their claim, and you want to be prepared. For instance, an employee may note that they work from home during COVID, so the employer should be able to provide it now. Don't worry though, both the courts and the EEOC have your back. Both have stated that just because an employer temporarily excused performance or essential job functions because of the pandemic and let employees work from home, that does not mean essential job functions have changed or that work from home is always feasible. That COVID-19 conduct won't be held against you. Employees might make a fuss about their request for work from home surely being reasonable in a more hybrid world. But remember, reasonable in everyday parlance is not reasonable under the ADA. We're working within the framework, not with what's fair. The employee may try to reject alternatives or say that work from home is all they can accept. But in the interactive process, the employer has a major say of what accommodation it offers, as long as it's reasonable. To close out my portion, always be thinking about these alternatives. My advice, be creative. Think of different ways to provide relevant equipment, workspaces, or scheduling, or other assistance that lets an employee perform their work despite their disability. At the workplace, try to manage equipment, volume, lighting, types of interactions the employee has to do, or even temperatures of the workplace. Those are all examples of what an employer can do to make a workplace better suited for an employee with a disability. Don't be afraid to give the employee extra time and space for their condition if needed as well, while at work. Be aware of how long the accommodation is needed for. Oftentimes, a disability will require accommodation indefinitely, but not always. An employee might have a time frame on when they'll get better. Tailor your responses accordingly. And again, pay attention to the medical records to see how long the condition may last. If it's not clearly indefinite, you may require updated accommodation documents as a later date as well. Make adjustments accordingly. Make sure that the employee is back to fit when they can work on site. Even if work from home looks like the only accommodation available, it may be worth compromising. Courts have recognized that partial work from home requests can be reasonable alternatives to full-time ones, or that work from home can be a temporary accommodation while facilities are being changed to better accommodate the employee. Finally, if you end up providing remote work as an accommodation, stay on top of whether the employee is still performing their essential job functions in the future. If the employee gets to work from home but starts to suffer work-wise as a result, then they may be unable to perform an essential job function itself, and another, more effective accommodation may be needed. Make sure to follow up. Work from home requests under the ADA are growing quickly and slowly becoming more successful when a dispute makes it to court. Employers need to know how to respond to one of these requests, but above all else, they need to be diligent in learning the facts needed to make necessary decisions in compliance with the ADA. I hope this has all been informative, and if you have any other questions, feel free to ask below or contact a labor and employment attorney here at Thomson Coburn. With that said, I'll give the floor over to Emma.
Thank you, Anthony. My name is Emma Lapp, and our final topic for today is a discussion of medical marijuana and state-level ADA counterparts. Marijuana remains illegal under federal law, even for medical use. Under the ADA, active users of illegal drugs, including marijuana, are not qualified individuals with a disability and are therefore not entitled to reasonable accommodations. Also, drug testing for illegal drugs is not considered a medical examination or inquiry under the ADA, so employers can test for marijuana and take adverse actions for a positive test under federal law. However, the ADA is not the end of the story here. The majority of states have legalized medical marijuana, and under many state law counterparts to the ADA, employees who use medical marijuana are entitled to certain employment protections. For our purposes, we're looking at marijuana or cannabis use in compliance with state law prescribed by a licensed medical professional to a person with a qualifying, debilitating medical condition for the purpose of treating or managing that condition. Employers should be able to verify whether an employee or applicant is covered under their state's medical marijuana laws. Regulatory schemes vary by state, but many states will have a registry of certified medical marijuana patients or will issue patients official patient ID cards. For example, Arizona has an online registry that employers can use. It's also important to note that your state standards for whether someone's medical condition qualifies them to become a medical marijuana patient may differ from the standards for determining whether someone is disabled under state employment laws. There's certainly overlap, but just because an employee is a medical marijuana patient does not necessarily entitle them to disability protections under state law. Consult your state's laws if you're handling a disability-related inquiry involving medical marijuana. And if you have state-specific questions, please contact us so we can help. The main issues we'll be covering today are which states have legalized medical marijuana, anti-discrimination provisions and adverse actions, workplace reasonable accommodation requirements for medical marijuana users, adverse actions for positive drug tests, and employer liability. 39 states, DC, and Puerto Rico have legalized medical marijuana, so all the states that are in dark green. I'll note that medical marijuana is technically legal in Nebraska, but is not yet available. There's ongoing litigation to overturn a voter-approved measure that was approved in November 2024. So right now, the laws do not provide specific information related to the employment context. There are also 9 states in light green that have legalized only CBD or low THC medical marijuana. We won't be focusing on these states during this presentation, but please contact us if you have specific questions about any of them. And then there are 2 states in red, Idaho and Kansas, where medical marijuana is illegal. 7 states, the ones that are in purple and with purple stripes, have anti-discrimination protections for medical marijuana users. The states that are in solid purple have provisions that specifically apply to the employment context, whereas Maryland and Michigan have general anti-discrimination provisions, but the statutes aren't specific to the employment context. In these states, you cannot discriminate against an applicant or employee in hiring, termination, or any term or condition of employment, or otherwise penalize an applicant or employee based on their past or present status as a medical marijuana patient or caregiver. In 14 states, the ones that are blue with purple dots, they also have anti-discrimination provisions in employment, but the provision is waived if the employer would lose financial or licensing related benefits under federal laws or regulations. 17 states, the solid blue ones, have laws permitting employers to take adverse action against employees who fail a drug test, refuse a drug test, or in some states, the mere fact that they have a medical marijuana card. Just because a state law contains employment protections for medical marijuana patients doesn't mean that they're completely immune from adverse employment actions. Private employers are still allowed to establish and implement drug-free workplace policies and take adverse action against employees for violating those policies. For example, employers can still take adverse action against an employee who uses, possesses, or is under the influence of medical marijuana while working. In fact, many of the states with anti-discrimination provisions specifically carve out that you can take adverse action for use, possession, or impairment in the workplace. And this brings me to my next subject, reasonable accommodations for medical marijuana use. So our orange states do not require employers to accommodate medical marijuana use at all. The pink states, there are 14 of them, may require employers to accommodate medical marijuana use. And New Jersey in green says employers must accommodate medical marijuana use. From the top, I want to make it very clear that no state requires employers to allow employees to come to work impaired as a reasonable accommodation. Courts in some states have held that employers may be required to consider medical marijuana use as a reasonable accommodation for qualifying disabled employees. So if you receive a request and you've got employees in one of these pink states or in New Jersey, this is the part where you call us for legal advice. So you do not have to let an employee use, possess, or be impaired by medical marijuana while working. You would participate in the interactive process to see whether any other reasonable accommodation aside from medical marijuana use would work for that employee. You would also want to look at your state's laws to see if there are any carve-outs for the employee's position, allowing the employer to prohibit off-duty marijuana use, such as safety-sensitive positions. For example, in New Jersey, employers are not required to take any action that would cause the employer to lose a federal licensing-related benefit under federal law, to violate a federal law, or to lose a federal contract or federal funding. If there are no reasonable alternative accommodations, call us to discuss whether there would be an undue hardship to your business. So if you've decided to offer the accommodation, or if your employee is in New Jersey and you're legally required to offer the accommodation, what is that accommodation? It would technically be permitting off-duty, off-premises medical marijuana use by the employee. And in practice, what that looks like is an exemption from the company's drug testing policy. Maybe that employee will no longer be subject to drug testing, or won't be subject to drug testing for marijuana specifically, or that they won't be subject to adverse action for testing positive for marijuana. You can and should still make it clear to that employee that they cannot use, possess, or be impaired by marijuana on work premises, during work hours, while on call, or while performing work duties, and that violating these terms will result in their termination. This brings us to our second secret word. Today's second secret word is criminal. Please select the correct word below. The second secret word today is criminal. Please select the correct word below. Okay, moving on. So I want to go into a little more depth on some of these pink states and explain the basis for considering off-duty medical marijuana use as a reasonable accommodation. So in Massachusetts, we're looking at a 2017 case that has great analysis you can use even outside Massachusetts to guide your thought process. In that case, the employer had a drug-free workplace policy. The employee had debilitating Crohn's disease for which she was prescribed medical marijuana, and she was fired for failing a drug test. Like with any other case, she first had to show that she's a qualified handicapped person, that's the terminology they use in Massachusetts, and that the requested accommodation of off-duty medical marijuana use was facially reasonable. The court noted that off-site medical marijuana use is not per se unreasonable as an accommodation solely because marijuana is federally illegal. So the state medical marijuana laws say that patients cannot be denied any right or privilege on the basis of their medical marijuana use, and a disabled employee has a statutory right or privilege to a reasonable accommodation under state employment laws. The court also held that the law's language precluding on-site medical marijuana use in the workplace as an accommodation implicitly recognizes that off-site medical marijuana use might be a permissible accommodation. So they instructed that the employer who had a drug policy that prohibited marijuana had a duty to engage in the interactive process to determine whether equally effective alternatives would work that would not violate the employer's policy, and that where no alternative existed, the employer then bore the burden of proving an undue hardship. Creating an exception to the employer's drug policy to permit off-duty medical marijuana use could be facially reasonable where, in the opinion of the employee's physician, medical marijuana is the most effective medication for the employee's debilitating medical condition, and where any alternative medication whose use would be permitted by the drug policy would be less effective. So in Nevada, the state law just says that employers must attempt to make reasonable accommodations for the medical needs of employees who hold a valid registry ID card, provided that the accommodations would not pose a threat, cause undue hardship, or prevent the employees from doing their jobs. In New York, skipping ahead a little bit, medical marijuana patients are automatically considered to have a disability under the New York State Human Rights Law and may require reasonable accommodation as would any other qualified individual with a disability. This presumption also means that any decision, such as a demotion or suspension, that you make once you know they have a medical marijuana card and therefore a disability may be inferred to be because of their disability. Some of the states with anti-discrimination provisions for medical marijuana patients also prohibit taking adverse action against patients for failing a drug test, as this could be considered disability discrimination under state law. Our purple states, there are 9 of them, allow employers to take adverse action based on a positive drug test for cannabis. Additionally, Washington allows employers to make initial hiring decisions on a positive THC-only test, and South Dakota allows employers to make decisions for employment against applicants and employees for safety-sensitive position based solely on a positive test. 8 states in solid blue allow employers to take an adverse action based on a positive drug test only if the employee used, possessed, or was impaired by medical marijuana while working. 10 states, the ones that are blue with dashes, allow employers to take an adverse action based on a positive drug test only if the employee used, possessed, or was impaired by medical marijuana while working, but a positive drug test cannot be the sole basis for determining impairment. So for example, New York requires specific articulable symptoms of impairment while working that either decrease or lessen the individual's performance of the duties or tasks of their job, or interfere with the employer's obligation to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health law. Specific articulable symptoms are not defined or listed in the statutes, but they are objectively observable indications that an employee's performance of their job duties is decreased or lessened, such as the operation of heavy machinery in an unsafe or reckless manner. But do be cautious, as what you see as symptoms of impairment from drugs could also just be symptoms of impairment from the disability itself. 10 states in green require employers to take additional steps before taking adverse action based on a positive drug test. So for example, Alaska, Minnesota, and New Jersey allow the right to explain the positive drug test, which can include providing documentation that they're a registered medical marijuana patient. Other states might require a secondary confirmation test. The important takeaway here is that taking an adverse action against a medical marijuana patient for failing a drug test could potentially give rise to a lawsuit for disability discrimination. So you do need to be familiar with your state's laws before taking adverse action for a failed test. Lastly, I want to discuss employer liability. 4 states in solid orange have statutes that expressly recognize a private right of action for discrimination or failure to accommodate under either their state's medical marijuana laws or the state's employment discrimination laws. 8 states, the ones with orange stripes, recognize an implied private right of action for discrimination or failure to accommodate. So their statutes don't explicitly provide a private right of action, but the courts in those states have read that into the statute. 4 states, the ones that are orange with dots, expressly recognize a private right of action for violating state drug testing laws. And 14 states, the green ones, do not recognize a private right of action by employees for discrimination or adverse action based on medical marijuana use. This means that the aggrieved employee cannot sue their employer for discrimination based on medical marijuana use, but it doesn't mean that they can't sue for ancillary claims like disability discrimination. And the 10 states that are shaded a slightly darker gray, their statutes do not address this issue. It's important to note that not every state that has anti-discrimination employment protections for medical marijuana users creates a private right of action for those employees, but you should of course still follow your state's laws anyways. So that was a lot of information about a lot of different states, but the takeaway here is that medical marijuana users in the workplace may be entitled to certain protections, just like other disabled employees, and may even be entitled to reasonable accommodations for their medical marijuana use. As medical marijuana users are starting to be treated less like illegal drug users and more like disabled employees in general, they can come under the protection of state employment laws. If you're facing employment issues with medical marijuana users and would like more specific information pertaining to your state or your factual situation, as Susan mentioned, is a very fact-specific inquiry, please don't hesitate to contact us and we will be happy to help you navigate that situation. So with any remaining time that we have, if anyone has any questions, please feel free to put them in the chat, and we will be happy to follow up with you via email as well for more detailed questions.
Thank you, Emma and Anthony, and thank you everyone for participating in our webinar. Please complete and submit the survey that we'll display at the end of the session, and enjoy the rest of your day.